Inherited wealth is extremely important to most people to pay a debt, buy a home, or to fund their retirement. It's increasingly important in maintaining living standards, particularly as we get older and into our retirement. It's not surprising, therefore, that it can be very distressing when an inheritance that had been expected doesn't materialise, particularly in the context of a surviving spouse or a long-term cohabitee who may have supported the deceased in building their wealth, contributed to the welfare of their family, and perhaps being financially dependent upon them, so that when they die, without provision or adequate provision being made for them, they are left in distressing financial circumstances. A disappointed beneficiary might be able to bring a claim against the estate of the deceased under the Inheritance Provision for Family and Dependants Act, 1975. Under the Act, the court has a power to make an award of reasonable financial provision for the applicant from the estate of the deceased. The practical effect of such an award is to give the applicant a share of the estate or a larger share than that which they would have otherwise received. Not everybody can bring a claim under the Act. Only certain categories of people are entitled to do so. They are the surviving spouse, civil partner or cohabitee of the deceased, the biological child of the deceased, anyone treated by the deceased as a child of the family, or anyone who was financially dependent upon the deceased in whole or in part. Crucially, a claim must be made within 6 months of the date on which a grant of probate or letters of administration are issued by the probate registry. The court does have a discretion to allow a claim to be made out of time, but that discretion is exercised sparingly, and so it's always important to take legal advice in those circumstances as to whether or not a claim can still be brought. A court will consider 2 questions when deciding a case. Firstly, has the deceased made reasonable financial provision for the applicant? If the answer to that question is no, then the court will decide what financial provision ought now to be made for the applicant. A higher standard of provision is to be made for surviving spouses. That is, such provision as is reasonable in all of the circumstances. The court will be very keen to ensure that a spouse whose marriage ends in death is not in a worse financial position than a spouse whose marriage ends in divorce. The starting point is therefore often equality of division of the matrimonial assets. But there is a strong argument to say that a surviving spouse in a claim under the Inheritance Act is entitled to more than half of the deceased's estate, because unlike in cases of divorce, there is only one surviving party to the marriage for whom provision is to be made. For all other applicants, the level of provision to be made is that which is reasonably required to meet their reasonable maintenance needs, and so that will involve an assessment of their current and future financial needs and resources. The court has a number of powers. It can make an award of a lump sum, or periodical payments, or the transfer of property. And very often, awards are framed around the need to meet an applicant's housing needs, to subsidise their living costs, to pay a debt, to help them fund the purchase of a home, or to fund their retirement. In order to be successful, therefore, an applicant has to show that they are a qualifying applicant, that the deceased did not make reasonable financial provision for them, that the court should now intervene to vary the distribution of the estate in favour of the applicant, and importantly and ideally, they should make that claim within 6 months of a grant being issued by the probate registry. Cases can often settle by agreement between the parties, either through negotiation between the parties or their solicitors, or with the assistance of an independent third party called a mediator. If agreement is not possible at the outset, then litigation will be necessary, and the court will then have to decide the case when it comes to trial. But very few cases do actually go to trial, and most settle by agreement beforehand. If you know someone who has died and they have failed to make reasonable financial provision for you, then you should get in contact. We offer a no obligation free initial consultation in order to discuss the merits of making an application. Here at Forbes, we have extensive experience of handling claims under the Inheritance Act and a proven track record of resolving claims successfully on behalf of our clients. We are very committed to practicing those things that constitute good client service from the client's perspective. We're accessible and responsive. We always push the case and update our clients. We stick to deadlines, and we have a transparent policy in respect of costs. We have a range of price and payment options from which you can choose the one that best suits your requirements, and we often act on a no-win, no-fee basis.